Hi, welcome back to Space Thoughts. This is the second half of the video that I did on lawfare and outer space. And this, and of course, in the first one we talked about lawfare in general terms, some of the history of lawfare, where the term came from, and a definition of the term, actually the original definition of the term, and my definition of the term. So I kind of laid the foundation with that video to try to get into actual outer space examples and talk about what I see is going on in the outer space environment as far as lawfare. And I want you to understand, and to kind of preface this, I want you to understand a couple of things. First, I hear a lot of people, we talk about the quote war in space, and whenever that phrase or that subject comes up, we talk about hard kill ASATs or some other form of space battle or Star Wars, and unfortunately the media really gets carried away with it. I look at the idea of quote war in space from a different tack, in that we're already in that type of battle, so to speak, and basically that tool is through lawfare. In other words, the law is being used right now to actually gain supremacy in outer space, so to speak, or basically to make things more difficult for other nations like the U.S. to actually operate in space or achieve what we call space superiority or space dominance. So understand that warfare is something that just doesn't involve kinetic weapons in the military. It's also something that involves the law, and in this case, lawfare. Second point I want to bring up about lawfare is that it doesn't operate in a vacuum in terms of its uses in warfare or as an instrument of war. Another aspect is politics, and I think politics and the law kind of go hand in hand in this when you're dealing with lawfare actions like this. In fact, the People's Republic of China has the concept of the three warfares: political, legal, and psychological, and they use those very effectively in combinations to actually further their interests. So I want you to understand that lawfare doesn't operate in a vacuum. And of course, my definition, which I'll show you again pretty shortly, basically says that the object of a lawfare action is to reach a political end, as is any military action. So we're going to get right to it, and we're going to go back to the last part and actually my definition of lawfare: to employ the rule of law and its instruments to augment or replace physical force to serve a national interest or achieve a geopolitical end. I want you to keep this in mind, and this is something whenever I'm talking about this subject or thinking about this subject, this definition is always rolling in my mind. And as far as whether a certain action in the international arena is really lawfare. So again, this is, as I explained last time, this is an evolutionary definition. This is what I've gotten so far. It's probably going to change in the future as I think about this more, and as I kind of apply it into different situations. So, how does lawfare affect outer space? Now, I mentioned in the last video that lawfare has been with us from the beginning of the space age. In other words, it's been a very active tool used in shaping the outer space environment. And really, in my opinion, again, I want to stress all this is my opinion, is really the first known lawfare action occurred during the Eisenhower administration. The Eisenhower administration really took space seriously. They were very concerned about how this new environment was going to be shaped, and the idea that the Eisenhower administration wanted, or the concept that the administration wanted to promote, was the idea of free access to outer space as opposed to national ownership. And this was really important. But the question was, how do you achieve this goal? They wanted this goal for numerous reasons. The Earth satellite program, obviously for science, but also for photo reconnaissance. At that time, the Cold War was really starting to heat up. There was concerns about the Soviet Union and the development of its missile programs and its bomber fleet. And of course, when nuclear weapons are in the mix, it makes for a much more complex world. So basically, what the Eisenhower administration was thinking, the satellite program would have a lot of great benefits for science, but it would also help us in national security by being able to look and see what other countries are doing. But the question is, how do we get this into the realm of outer space? How do we get this as an accepted practice, or actually accepted international law? The problem at this time was the Soviet Union had made national claims to outer space. In other words, it basically says everything from the ground all the way up into outer space above the Soviet Union is our territory. We've nationalized it, and that includes the space above or in orbit. Now, I'm going to emphasize this because this is going to be very important when I talk about it a little bit later in the context of some academic writings and some actual lawfare actions that are taking place right now that are looking to move back towards this. But just keep that in mind. The Soviets at the time said, we own space all the way up to the top. And the Eisenhower administration was, how, short of a war or short of, a political disaster, how can we get this idea of free access cemented in, especially when you have a competing claim by the Soviet Union? Well, the Soviet Union did a very interesting thing on October 4th, 1957, and they launched this little sphere called Sputnik aboard one of their converted ICBMs. And what happened to that was basically that satellite passed all over around the planet, over many nations, over many state lines, and in essence, under their theory of nationalism in outer space, they violated territory. So the Eisenhower administration looked and said, you know what, this is interesting. The question is, do we object to this, or do we use this for something, or we use this to our benefit for free access? And basically, right out of a memorandum, declassified memorandum, another of our objectives in the Earth Satellite Program was to establish the principles of the freedom of outer space. That is, the international rather than the national character of outer space. In this respect, the Soviets have proved very helpful. Their Earth satellite has overflown practically every nation on Earth, and there have thus far been no protests. So fundamentally, the Soviet Union basically gave a gift to the United States, because the Eisenhower administration latched onto this and said, you know what, no nations have complained about this satellite overflying their state, their sovereign territory. So why don't we use this to actually create the principle of free access? And that's what happened. It is basically, the Eisenhower administration asserted this, and actually the Soviet Union pushed back and tried to save their nationalism claim by saying, well, look, Sputnik wasn't going over the territory of other states. The Earth was revolving around Sputnik, which was a nice try at at saving their idea of nationalism, but it didn't quite work. So fundamentally, the Soviet Union's action of Sputnik 1 and then again with Sputnik 2 contradicted their claim of national sovereignty over outer space, and gave the Eisenhower administration the means to apply lawfare using customary international law to pursue the goal of free access to outer space to support a national interest. Go back to my definition of lawfare. Basically, what the Eisenhower administration did is they used lawfare, they used customary international law and the actions by the Soviet Union to create the idea of free access to outer space. Perfect example. No shots were fired. There wasn't any heavy arguments in the United Nations about this. There were no ugly memorandums that we know of that haven't been declassified, but fundamentally, that action was used to create a customary international law and the idea of free access in outer space, which was codified in the Outer Space Treaty and which we enjoy today, because we have thousands of satellites in orbit, and this has become a principle of really the bedrock of outer space law as we know it. So fundamentally, as I said before, the outcome of this lawfare action, this brilliant use of lawfare, even before lawfare was a term, was to create the principle of free access to outer space. Now, I want to do a little bit of deja vu here, because back in when I talked about lawfare initially in the last part, I talked about Grotius and the effort of Netherlands to gain free access of the oceans through their formal legal argument in Mare Liberum. So fundamentally, what the Eisenhower administration did is they took the same principle, or took the same tack as Grotius did in the 1600s, and applied it to outer space. Free access of the seas versus free access in the outer space, both achieved by using lawfare and not really having to use physical military force or any other really messy means to gain that international norm. So that is probably the first example of lawfare in outer space that we know of. There could be something hidden away in that's still classified because of national security reasons that we don't know about. But this is the one that stands out, that creates in my opinion, the first recognizable lawfare action in outer space. Now, the Soviets weren't very happy that they really kind of got played into the idea of free access in outer space, especially because of the utilization of space for remote sensing. So prior to the Outer Space Treaty, there was this document called the Draft Declaration of the Basic Principles Governing the Activities of States in Pertaining to the Exploration and Use of Outer Space. Basically, this document was the progenitor to the Outer Space Treaty, and in a lot of cases, they're basically the same document for the most part. The Soviets went to the UN, and when negotiating this, basically they tried to undo some of the damage that occurred because of Sputnik, especially with regard to use of remote sensing satellites. And basically they wanted to include a clause in this declaration that basically says the use of artificial satellites for the collection of intelligence information from the territory of foreign states is incompatible with the objectives of mankind in its conquest of outer space. So, in this case, the Soviet Union is taking a different lawfare tack. They're using an international organization and using that venue in a draft declaration, a draft resolution here to basically go in and try and undo the damage that Sputnik did, especially with regards to remote sensing. Because, again, the idea of remote sensing definitely was a windfall for the U.S. in particular, because it gave the ability to actually photograph large areas of Soviet territory during the Cold War that would otherwise, have to be done by manned or unmanned aircraft. And of course, we all are familiar with the U-2 incident in France's Scary Powers. That caused a big problem. And really, when those aircraft are going there over there, they were violating international law. They were violating sovereign space. So essentially, what the Soviets trying to do is they were trying to undo the damage here. And well, it didn't work. And they put this in. They fought about it, but it never got adopted. So they tried to do it, but it didn't work. But again, another example of lawfare in outer space. Another example that I've really tagged on to, and it has more really to do to a political objective. And again, look at my definition of lawfare, and basically a lot of the ultimate goal of lawfare is for political objectives. During the 60s and 70s, and even into the 80s, anti-satellite weapons were really a big hot topic. And again, this is where the idea of space weapons was really hot around that time. During the Carter administration in particular, the Soviets really wanted to get, saying we really got to negotiate some sort of ban on these type of weapons. Now, basically they were asking for an arms control agreement. So the Carter administration basically was kind of skeptical about how sincere the Soviets were about this, and they wanted to actually gauge their interest, try and actually gauge some political intelligence on this. So basically, the Carter administration issued a directive to open negotiations with the Soviets on ASATs. And fundamentally what they were is to talk with them, and basically on a certain set date. And one of the goals was not so much to to get to an agreement, but to find out how sincere or how badly the Soviets wanted this agreement. In other words, to gain some sort of political intelligence, to gain this objective of finding out what the Soviets' intentions were in this matter. So in this case, lawfare was used. The setting of a negotiation for an arms control agreement was basically used to gain political intelligence, to gauge whether the U.S. should commit to something like this or not do it. So again, and again, sometimes a lot of these, and I think I discussed this last time, treaties sometimes are negotiated or proposed just for the political benefit, as opposed to really getting a solid legal norm or law established. If you get the law established, that's a bonus, but really fundamentally at the bottom line, sometimes these treaties are proposed or negotiated just for the political benefit of it. And in this case, this is what was happening with the Carter administration. And again, this is one instance that happened in the Carter administration. Another interesting lawfare declaration wasn't by the U.S. or the Soviet Union, but actually by the nations that sit along the equator. There was this idea called the Bogota Declaration, and basically what the states along the equator says is, we understand that geosynchronous orbit, which basically at an inclination resides right along the equator, is a very important resource. And actually, it's a very finite resource just because of the nature of it. All these equatorial nations basically got together and said, we claim space all the way from our ground all the way up to geosynchronous in orbit. In other words, we own us nations along the equator. We own geosynchronous orbit. Now, the implications of that are pretty heavy. One, these states were trying to nationalize outer space. And on the same accord, if this was successful in actually becoming a recognized norm or a recognized law or legal precept, that would put that would basically put that resource at the disposal of these nations, and they could charge huge fees to actually gain access to it. In other words, for a satellite to, quote, violate their territory, they would have to have an agreement with these states one-on-one. So, to say the least, it didn't go over well with most of the other states in the world, because they understood, one, this is nationalizing outer space, and two, the geosynchronous orbit is a very vital asset. So there was a huge pushback against the Bogota Declaration. What I want you to understand is what these nations were doing was basically lawfare. They were they were setting out this idea and trying to establish a customary principle that would be accepted in the international community, that they owned geosynchronous orbit. Fortunately, there was enough of a pushback, especially among the big players in outer space at the time, which was the United States and the Soviet Union, that we disagree with this vehemently, and we're not going to, we're not going to support this. In fact, we're going to outright oppose it. Another interesting thing that actually came out of this declaration was the U.S. in its response to it, basically as an addendum said, oh, by the way, we recognize that that commercial space activities are consistent with the Outer Space Treaty. In other words, the actions of private activity in outer space is not inconsistent with the Outer Space Treaty, and therefore we support this. And this is where the U.S. kind of set some policy and set some interpretive law, and basically did a little bit of other additional lawfare on its own to kind of till the soil for commercial activities which are quite prolific today. So those are some examples of what's happened in lawfare in outer space, and I'm going to go back to a few slides that I did in the first part to go back to the tools of lawfare and try and plug them into some of the things that are going on today. So, as I said, lawfare employs several tools: treaties, domestic law, customary international law, norms, soft law, and non-binding measure. And I'm going to lump those, 1, 2, 3, 4, together, because they are really all the same. They're essentially customary international law, and we'll talk about those in a moment. Treaties, they're frequent. These are the big, very public, very very blatant expressions of what international law is. They're very formal. These are what we call top-down measures, where basically states get together, they agree to the treaty and sign it, and it becomes international law once it's ratified, has enough ratifications, and is actually put into practice. Now, the Outer Space Treaty in particular is the foundational document. I mean, it's signed by almost virtually every spacefaring nation in the world. But during the negotiation, what isn't understood is a lot of things didn't get included in that. And one of the things that didn't include was the idea of, quote, I'm going to call space weapons, and I'll put that in quotes, as I usually do, because of the fluidity of that term. Fundamentally, what the U.S. said is, during the negotiation for the Outer Space Treaty, they looked at the Soviet Union and said, look, let's talk about space weapons. Soviet Union didn't want to do it, because basically they said, you know what, we don't want to talk about space weapons in the Outer Space Treaty. We want to talk about that for late. We'll do that in separate agreements in, like, the Conference of Disarmament. So fundamentally what the Soviet Union did was perform a lawfare maneuver. Instead of dealing with the issue of space weapons right in the Outer Space Treaty and say, okay, this is what we're going to do, we're going to talk about this, we're going to lay down some rules or some principles right here. We don't want to do this because we think it's better utilized in separate arms control agreements. Now, arms control agreements are basically lawfare tools. In other words, the idea is basically to make an issue of it, and unfortunately, the real tendency behind arms control agreements is to prevent an adversary from gaining a capability while you yourself develop the capability. Yeah, that sounds negative, but it's reality. This is realpolitik, and I'm not going to sugarcoat it because that's what it is. You can complain about it in the comments if you want. That's fine. I'll let you do that. But the idea is the Soviet Union wanted a lawfare tool down the road to talk about space weapons and to muck up the works. And really, it has been really, the works have been mucked up right through, right up to present, as we'll talk about in a little bit. And I think one of the things we can talk about is the PPWT and Paros. That's something the Soviet Union, the Russian Federation and the People's Republic of China have been pushing very heavily for going on a long time right now. It hasn't gotten anywhere, and in fact in 2018 the US basically burned down the whole idea of the PPWT and the space weapons argument in Geneva, and right now the Russian Federation and the People's Republic of China are trying to rebuild that effort, and we'll talk about that a little bit more. Domestic laws are another avenue of lawfare, and one in particular is the space resource law that's codified in Title 51, Chapter 509 of the United States Code. Basically, the space resource law empowers private actors to recover and possess extraterrestrial resources and provides a bottom foundation for the state to pursue a national interest and change international law to permit the former. So in other words, this law that was passed and signed into law in 2015, November of 2015 actually, basically says that, created the idea of space resources, and since then the U.S. has been taking this up to the UN level and negotiating it and trying to getting this accepted as actual being consistent with the Outer Space Treaty, and actually I think in more or less trying to create a customary idea of space resources. Now in the last administration, in fact last year, did some serious domestic, actually built on this with an executive order, and of course the Artemis Accords, which I think are another lawfare tool that is basically designed to form international law from the bottom up, as opposed to formal treaties in the UN. So that's an example of how domestic laws can be used to influence international law. And of course this is all simplified. It can get terribly complex, but again, we don't want to stay all day here on a video. Now we kind of get into the tricky one: customary law, international law, soft law, non-binding measures, and norms. And I lump these all together because, excuse me, these are basically customary. This all deals with customary international law. These all can be lumped into customary international law. Non-binding measures are often proffered as alternatives to legally binding measures. Much emphasis is placed on the non-binding nature of these instruments, but they can be backdoor attempts to use customary international law to make the principles within legally binding. I talked about customary international law in a video, and it's sneaky, it's shadowy, and it's really insidious because it can creep in and get you stuck if you're not careful into something you didn't intend to. So. And there's a lot of examples. In fact, this is in lawfare today. This is especially in outer space. This is the weapon of choice. This is the preferred weapon of choice. Customary international law, and all these little soft law, non-binding measures, and norms. I haven't done a video yet on norms just because I'm not sure how I'm going to address it, but I will think about that and try and get something out about norms. But examples of soft law and non-binding measures for outer space used in lawfare. The EU/International Code of Conduct. This was an effort started by the EU. It kind of lost momentum, and it was taken up as the International Code of Conduct. And fundamentally, this did not do well. It basically failed. But I personally was very critical of it because, in my opinion, it was a backdoor attempt to create customary international law through soft law. A colleague of mine, Jack Beard, actually wrote an excellent article on the Code of Conduct. If you do a search engine search for it, Jack Beard and the Code of Conduct, I'm sure you'll come across this paper. Very well done, very thorough on all the politics behind it and all the concerns about it. But fundamentally, I was very critical of this because the Code of Conduct I saw it was just talking about non-binding. These non-binding things can become legally binding if they become customary international law, especially if a state like the U.S. adopts it. Rules being collated by academia. There are two efforts now between two separate efforts to create manuals for rules, international rules for military law. And the idea behind these is they're going to be very, these are going to be very specific and not really, in my understanding, not leave a lot of wiggle room. I'm very suspicious of these just because of the simple fact that, these are being promoted as something that the creators of these want these actually adopted by states. And actually, once states start adopting them, even though they're being advertised as non-binding, customary international law can creep in. So I see this idea of manuals for rules for military activity in outer space as being a lawfare tool that could be used or abused. And actually, a couple of years ago, I went to a conference, and there was a panel by one of the efforts on this. And granted, they were extolling this effort and everything. And my question, the last question of the session was, well, what if the other side doesn't follow the rules? And well, I got a lot of silence from that. There really wasn't an answer. I mean, I got a few non-answers from some member of the panelists, but the general, talking to one of the members afterwards, the remark was basically, you threw a monkey wrench into everything. So understand the idea about lawfare. Remember what I talked about with the PRC, and in a lot of cases, the Russian Federation as well. They will ignore the policy. The strategy is, if it's going to gain me a strategic advantage, I can ignore the rules. So I see these rules as being a lawfare tool, a potential lawfare tool that could be used against, countries like the U.S. who if they subscribe to them, will be caught to them. And my analogy is, well, basically, if the PRC, the Russian Federation starts zapping satellites with anti-satellite weapons, what are you going to do? Flipping through the rule book isn't going to help, because there's no referee and nobody to throw a flag and say or cry foul. I mean, you can look at the book all you want, and that's great. But if they're going to ignore the rules and hit your satellites anyways, what's the point? Transparency and confidence building measures, TCBMs. These are sneaky little devils, just because the fact is TCBMs are precursors, are really intended as precursors to legally binding arrangements. So I know the U.S. has been leading an effort in the United Nations, and the group of and I think in the group of governmental experts in particular, for TCBMs. Good effort, but the problem is it really isn't going anywhere, because the whole idea is, even though these things are, quote, non-binding, the real intent is to gain a legally binding agreement. So I really see these as a lawfare tool in and of themselves. Guidelines for sustainability. These were just agreed to a couple years ago. They're very vague, and they still got to sit down and decide what they mean. These are supposed to be, again, non-binding. They're not legally binding. But the idea is, once you agree what they mean and you start acting on them, they could become customary international law, and that could be used as an advantage. So you got to be careful when these things are actually fleshed out. When they decide what they're going to mean, they got to be very careful how they do it. I think the U.S. is doing a good job in that regard, and actually negotiating these and kind of keeping things in check. So those are some examples of some non-binding measures, customary international law. Like I said, I think customary international law is the weapon of choice for lawfare, just because it's really sneaky and insidious. And if you can get your opponent to agree to a rule in a non-formal sentence from a customary standpoint, and it's very easy for another state to ignore it to their advantage, and basically also use politics to explain and to shame the other side into obeying the rule. Again, this is lawfare. It's law of the jungle in some senses, and it's something we got to be aware of. Some of the actors in lawfare. I think number one of them is academia. How does academia basically actually create lawfare or be involved in lawfare? Well, there are several. One of the primary ways is writing scholarly papers. If you write a paper, and say I wrote a paper putting out this idea that I wanted to really gain steam and actually catch on as a binding rule of law. Well, I'd write the paper and I'd publish it in a journal, and my hope is other people would cite that paper and cite that particular idea, and it would propagate and it would grow and grow and grow and snowball to the point where people would look at it and say, oh, this is an act, okay, this is a good idea, maybe we should implement it. And then they would talk to a policymaker and say, this is a good idea, maybe we should consider it. If they negotiate that, if it gets put into practice, it becomes customary international law. A really good example of that is space resources. Before the idea of space resources actually was passed by Congress and signed into law by the President Obama at that time, it was basically an idea of academia was talking about this and putting that idea out and basically making it grow in size until it got accepted. Now it's in the international arena being talked about, and it's actually gaining a lot of legitimacy. The delimitation of outer space and the atmosphere. A lot of scholars right now are talking about this. Basically, in the case of the United States say that we don't recognize a physical boundary between space and outer space. But there are a lot of scholars out there, a lot of universities writing papers about this idea and promoting it to try and gain steam for an actual demarcation of where outer space begins and the atmosphere ends. Again, the idea is the more you write about it, the more it becomes accepted as fact. And once it becomes accepted as fact, you can use it as a legal tool or a legal weapon to further your national interest. Nationalization of outer space. Now, we talked about this with the Soviet Union. One of the first things they did is they came right out during the space age saying, we own space all the way from our territory, from the ground all the way up into outer space. And that basically got nixed. There's a lot of scholars in the People's Republic of China who are trying to reinvent the idea. Basically saying we own we have sovereign control over the ground all the way up in outer space. And the idea is, if they can get that to gain steam, if they during the openings of a war, a conflict with the United States or another state, they could basically justify shooting down a reconnaissance satellite that traverses overhead. In other words, the idea is they want to create a legal precept that basically says once this activity takes place, once the intercept of a satellite passing over the sovereign over their territory takes place, they can point to their scholarly writings, their writings, and say, we believe what we did is consistent with international law because we believe we own all the space above our territory, now even including the orbits. So understand, people say, well, that they aren't really doing that. They really can't do that. Do not underestimate the power of the influence that academia has on lawfare in particular, and in creating these ideas. And it could happen very, very easily. And we talked about formal rules for military activities in outer space. In particular, like I said, there are two efforts being spearheaded by institutions in the U.S., Australia, and Canada. And I've already talked about my concerns about those in the prior slide. Something to watch. This is something that you got to be careful about because it could come back and haunt you in the future during a conflict. NGOs, non-governmental organizations. These are my favorites. I consider NGOs really the foot soldiers of lawfare, foot soldiers out there, because basically what they do, what NGOs do, these things can pop up out of nowhere and gain legitimacy, get nonprofit status, get funding from multiple interests, and basically create these ideas to influence international law. The biggest weapon right now, weapon of choice for NGOs, is norms. And again, I really got to do a video about norms because I have a lot to say about it. I just don't know how I want to say it right now. But fundamentally, I consider norms a narrative. Norms really start as, in my opinion, narrative. The idea is, say I want a certain precept of international law to become, a precept or idea to become international law. Well, I could just I could come up with this idea and start promoting it on social media, in writings, and if I'm an NGO with a particular goal, geopolitical or geolegal goal in mind, I can start promoting that idea on my social media, in my writings, in my institution's writing, and I could get outside entities to actually fund me to promote this idea. So norms essentially become what I call, they become narrative and eventually grow and evolve into actual customary international law, which makes them very, very fluid, very slippery, and something you got to be cautious with. And here, and an example of an NGO invoking a presupposed norm, India, just about actually 2 years ago, tested a direct ascent ASAT against one of its satellites, and obviously destroyed it, caused a huge kerfuffle. And at that time I was very active on social media, and I was watching what was going on social media, and some articles, and this thing popped out that the India's ASAT test violated the norm of non-destructive testing with an ASAT. And I was like, okay, where did this come from? And in my opinion, I really pushed back on this very hard on social media at the time, and I also talked about it in my briefing letter to the press in a special issue about the ASAT test. My idea was there is no such thing as this norm. There is no norm of non-destructive testing with ASATs. It just doesn't exist. But this, in my opinion, again, was something NGOs were pulling at. Were basically conjuring, creating a narrative to try and create momentum to actually create, a recognizable legal precept in the international community. Kind of think of norms as they basically start as gossip, and how the thing with gossip is, if it isn't really nipped really quickly, it'll evolve, and people will start accepting it as fact, even without any evidence to support it. So fundamentally, norms can start as gossip, and in this case, my opinion, this was basically narrative gossip that was trying to be spun up into a actual factual legal precept. So don't underestimate the power of NGOs. Like I said, they can pop up very quickly, and once they get nonprofit status with their respective governments, they can become very effective at influencing international law. And a lot of times it isn't for the benefit of state actors, and sometimes state actors like to use NGOs and they'll fund them in indirect ways to actually promote, to help them promote these things. Again, that's my opinion. If you want to get angry with me about it in the comments, do so, but I have the right to moderate. So we've talked about this idea of lawfare, and in last part I gave you a really good long dissertation about what lawfare, in my opinion, is, and I gave you some examples of lawfare in outer space. And this is a question that's been bugging me a lot. And I've read Clausewitz on war, and Clausewitz was very focused with force, the idea of force as a tool of to attain a military objective. My thoughts over the past couple of years has been, the question is law force? Now, Clausewitz was very, looked at laws and saying, okay, laws are great, but they really are more about limiting force as opposed to being force. I disagree. I think now, and I think, and that's, of course, this is written back in the 19th century. On war was basically compiled back in the 19th century, and really when Clausewitz died at a rather young age, he really hadn't completed his thoughts on the idea of war. I really question nowadays if he could see what is transpiring in the international arena and how law is being used, whether he may reconsider whether law is force. I think it is. Personally, I think law is force. I almost wrote a paper a few years ago about this. I still might write it. But fundamentally what I'm thinking is that instead of law being a limiting factor, the idea of lawfare really creates law as force. I've had talks with some colleagues about that. They disagree with this, and disagreement is good because it makes you think about, it makes you look at different perspectives and look at your idea and see if it still has merit. Like I said, I think law is force. But again, you got to bundle it with the idea of political warfare and psychological warfare. And again, I think the People's Republic of China does a brilliant job with it. The Russian Federation to a lesser extent, but they recognize how all three of these factors, with law political and psychological with law sandwiched in between, basically make for a very effective non-kinetic means of waging war. And people ask, and again, like I started this video, I think, in a sense, we are at war in a sense. I told you at the beginning of my part one of this two-part series that I look at war as an adversarial process. When I do a litigation, I look at it as war. I don't look at it, as a friendly altercation. I have an objective to achieve for my client, and I'm going to do it. And there, of course, there are rules, and I use those rules to my advantage, and so does my opponent. So that fundamentally is this series on lawfare and outer space. Again, as I mentioned at the ending of last video, this is a very opaque subject, very subjective, and I'm thinking about this. I think about this a lot. Like I said, I write about this in my briefing letter to the Pressy. I actually have a section dedicated in my quarterly issues. I think this is very powerful. I think the U.S. in particular could use this a lot more to its benefit if we start thinking more in terms of using law as a weapon instead of being reactive with it. And of course, I've had discussions with people about the application of law as a weapon as well, and they've been very interesting discussions, to say the least. This is something I actually do with my company, Space Law and Policy Solutions. Actually, one of the things that this company does is it talks about lawfare with clients. Sorry, I only do domestic U.S. clients. I don't do foreign governments, just for national security, just for purposes of for obvious purposes. But the idea is, Space Law and Policy Solutions does talk about, work with clients on lawfare strategies, analyzes lawfare and such. So a little bit of an advertisement there. So that's the end of part 2 of my 2-part series on lawfare. I hope you enjoyed it. This was a little longer than I intended it to be, but I wanted to get an idea of where some of my thinking is on this. Again, it isn't my complete thinking on it, but to give you basically a gloss of the idea of lawfare and how it's applied to outer space. So again, holiday weekend's coming up. I hope you enjoy it. I hope you're safe, and the weather here in the northern hemisphere anyway is turning out nicely. Stay safe and stay healthy, and I will talk to you next time.